me see.
Okay, sir. Good evening, all. Sir.
Go ahead.
Okay. I'm thrilled to welcome you all to today's webinar hosted by Sri Venkateswara Law Students Association. As we gather here today, we embark on an enriching journey into the realm of intellectual property and technology law, exploring the dynamic intersection of innovation and legal framework. At SVLSA, we are committed to fostering a vibrant community of legal scholars and practitioners and students dedicated to advancing knowledge and understanding in various areas of law. Our webinars serve as invaluable platforms for learning, discussion, and networking, connecting legal enthusiasts from diverse backgrounds and experience. Today's webinar titled Unlocking Innovation, Navigating Intellectual Property in the Age of Artificial Intelligence holds immense significance in today's rapidly evolving legal landscape in this digital and AI era. In an era characterized by unprecedented technological advancements, presents both opportunities and challenges that require careful navigation and informed decision-making. Our esteemed speaker for today's session, Mr. Alban Kang, brings to the table a wealth of expertise and experience in intellectual property and technology law with nearly 4 decades of practice. Mr. Kang has established himself as a trailblazer in the field, renowned for his exceptional skills in handling complex patent litigation and contentious IP-related matters. His illustrious career is marked by numerous accolades and achievements, including his induction into the Legal 500 Hall of Fame for intellectual property in Singapore. As a senior consultant at Bird & Bird firm based in Singapore, Mr. Kang's insights and perspectives on intellectual property issues are highly sought after, both regionally and globally. Throughout today's webinar, we have the privilege of delving into Mr. Kang's vast reservoir of knowledge, gaining valuable insights into the intricate nuances of intellectual property law in the context of artificial intelligence. I have no doubt that his expertise will enrich our understanding and empower us to navigate the complexities of this fascinating legal landscape. So without further ado, I invite you all to join me in extending a warm welcome to Alban Kang. Sir, I would like to continue with the webinar.
Right. Thank you very much. Can you all hear me?
Yes, sir.
Okay. Right. Well, the topic for today's, or the title of the webinar is Unlocking Innovation, Navigating Intellectual Property in the Age of Artificial Intelligence. There's actually a lot to talk about in this field. So I've actually just tried to narrow down to some of the more current issues that's happening here in Singapore and in a few other countries. Let me just try to share screen. Can I try to share my screen so that you can at least see my slides? It says disable share. So is there a way that you can enable me to share the screen? You're on.
So we have enabled to. Pawan, can you enable the screen sharing for sir?
Okay. I think I got. Let me just. Okay. Let me try and let me know if you see the PowerPoint presentation.
Okay, sir. Okay.
Are you able to see the presentation?
No, sir.
Okay, just give me a minute.
Okay, sir.
So now you can share.
Now I can share, is it?
Yes, yes, please.
Okay, let me try again and see. Can you see?
No, sir.
Let me see what's happening.
It's already enabled. Can you please try again, sir?
Let me try again. Okay.
Otherwise, you can please share it with us. We can.
Do I need to click share? Is it? No. Entire screen. Yes. Cancel. I'm going to share screen. I press the green button, right? It says share screen. But I get. How do I? Entire screen. And let me see. Are you able to see anything?
No, sir.
I'm not sure what's happening. Okay, let me go back up again. And its impact on two aspects of intellectual property, which is really on the patent side and on the copyright side. So let's deal with patents, which is a bit easier. With the development of AI, and it gets more developed along the way, and the next generation of AI, obviously, it's better than the previous generation. Issues have arisen in a number of jurisdictions as to whether an AI can be an inventor of a patent. And also the other issue is really whether or not AI plays a role in the discovery of the invention, and then what is the test for obviousness in granting a patent if the AI was involved in developing the invention. I'm sure you've heard of Mr. Teller. Mr. Teller was the developer of a AI known as Darius. And with the help of Darius, he invented a machine, an invention. So he then tried to file a patent application in various jurisdictions, United States, and in the UK, as well as in Australia. And in the application for the patent, he listed Darius, the AI, as the inventor. So this is where we are now. So you've got Mr. Teller, who developed the AI Darius, and then Darius comes up with an invention, and he tries to file an application for Darius as the inventor of the invention. Okay, I got your email. Let me just reply this.
Okay, sir.
Yeah, just give me a minute. Okay, I've sent you back the slides. Thank you.
Okay, sir.
You got it?
No, just checking, sir.
So maybe you can put up the slide, then it'll be easier to you know what I'm talking about.
Yes, sir. I will share it.
So anyway, to continue, so Teller files an application with the USPTO to file for a patent naming Darius as the inventor. Obviously, the USPTO rejected the application, and therefore Darius took the USPTO to court. Now, the USPTO, of course, took the position that an inventor of a patent has to be a natural person and not a AI. All right. So when the first round was in the district court, the district court said no. The question of whether the Patent Act requires that an inventor of it is a human being is a question of statutory construction. So it's a question of law. Yeah, can you just go to the third slide? Next one. Yes. Okay. Right. We're talking about the US case now. That's right. Okay. So it went to the district court. The district court turned down the application and said no. Under the US Constitution, the right to be granted a patent goes to a human being, a person. Teller then appealed to the U.S. Court of Appeal, to the U.S. Court of Appeal of the Federal Circuit, and the U.S. Court of Appeal of the Federal Circuit also came to the same conclusion. It rejected Teller's arguments that the U.S. patent law allowed an AI to be an inventor, but that was rejected by the U.S. Federal Court of Appeal, and that was the end of the matter as far as the U.S. is concerned. Teller tried the same thing in the UK. All right, he tried to file an application before the UK Patent Office, and it was rejected because under the UK Patents Act, it states that the requirement is of an applicant has to be a natural person. So Teller didn't agree. He argued that the Patent Office had construed the Patents Act incorrectly, and that it was wide enough to include an AI. It went up to the UK Court of Appeal, and the Court of Appeal held that the same thing. Basically, under the UK Patents Act, an applicant for a patent has to be a natural person. And then Teller was still not satisfied. He appealed to the UK Supreme Court. The Supreme Court actually issued a judgment very recently, I think in December last year. And the UK Supreme Court also ruled that as far as an applicant for a patent is concerned, under the UK Patents Act, an applicant has to be a natural person. So that was the end of the matter for Teller, both in the US and in the UK. And it's quite clear in those two countries that an AI cannot be an inventor or an applicant for a patent. It has to be a natural person. Teller also tried in the UK, in Australia, and it got slightly different result. It took a slightly different route, but it came to the same conclusion, basically. So Teller filed an application, which was, of course, then rejected by the Australian IPO office. The first instance, which was the federal court, held that an inventor is an agent now, and an agent can only be a person or a thing that invents. It would be more accurate to apply natural meaning of the word inventor, and therefore an inventor, has to be a natural person. Teller then appealed to the Federal Court of Appeal. And interesting enough, at the Federal Court of Appeal level, the Federal Court actually held that, an AI could be named as an inventor in a patent application in Australia. Obviously, the Australian Patent Office was not happy, and it appealed to the full Federal Court of Australia, which then held that given that there was no definition of inventor in the Patents Act, the standard dictionary meaning should apply, and there was no evidence that an inventor can include a machine. And so the court held that an AI cannot be an inventor. It has to be a natural person. So you have in those countries, the US, the UK, and in Australia, ruling that under the applicable law, patent provisions, an applicant for a patent has to be a natural person. We have not had this issue decided in Singapore as yet. However, there have been cases in Singapore, for example, the energetics private limited case, which has made reference to the fact that an applicant for a patent or an inventor has to be a natural person. Can we have the next slide? So what we have in Singapore under Section 19 of the Patents Act, which is parent material to the provisions in the UK Patent Act that was decided in the Teller's case, it says any person may make an application for a patent either alone or jointly with another. So the court actually ruled on this provision in the UK and held that the word person, that any person must mean a natural person and not an AI or a machine. So with the UK decision of Teller, the UK Supreme Court decision of Teller, it's very clear, at least in those jurisdictions which follow closely UK patent law or have statutes that are closely similar to the UK statutes, that a machine cannot apply for a patent. An applicant for a patent has to be a natural person, and therefore AIs are not entitled to any protection. So that deals more or less with the issue of whether an AI can be a applicant for a patent or own a patent. But there's other issues that have come up in relation to AI and patent law. For example, if a machine is used to help create the invention, one of the requirements of a patent is it has to be not obvious. It should not be something that would have been obvious to a skilled person in the art. And the case law and the in most patent jurisdiction states that the state of the art is what is known to a hypothetical skilled person in the art, right? And then you use that as the foundation of determining whether or not the invention would have been obvious to this skilled person in the art. So the question comes about as to, what if an AI is used to help create the invention? All right, an AI goes through all the various different permutations and come out with the results. The permutations may not have been humanly possible or may not have been obvious to a human, but since the AI is programmed to analyze the algorithms, it comes out with a solution. So the question then is, a AI-generated invention considered non-obvious or obvious to a skilled person in the art? Again, this issue has not really been decided in any of the jurisdictions, and it'll be interesting to see how this develops in the various courts. AI is now used in a lot of R&D departments in the universities and research institutes, and the question will definitely come one day as to how AI created inventions will change the law or the test for obviousness in determining the validity of a patent. Until then, this is a live issue. And so it's something that I guess we would wait and see, or watch this space, as they say, and see what the courts come up with. So these are the two main live issues that we have in terms of AI and patent law. One is fairly settled. An AI or a machine cannot be an inventor. The other one is open to, I guess, further consideration, whether an AI developed invention, it will be considered non-obvious to a skilled person in the art or obvious to a skilled person in the art. We'll have to wait and see. So that deals with AI and patents. Can we move to the next slide, please? AI and copyright is a bit more technical, and it's also raised some very interesting issues. There are two sides to AI and copyright. One is what we call the input related side of copyright. In other words, when you use AI to create something, or when you create an AI to help you create other works of copyrightable nature, is that considered infringing use, right? So this issue has been addressed in a few cases. And then and the other area is, of course, output related, similar to the issues in patent law. Where can an AI created work be entitled to copyright protection, i.e., can AI be an author, or an AI be a co-author if, for example, the author, a real person, uses AI to create the work. Yeah, so very interesting issues. Can we move to the next slide? Yeah, so we do have a number of cases here in various jurisdictions. In terms of what's happening in the US, there are a number of cases going on. You have the class action against GitHub Microsoft. You have a class action against DeviantArt, and then you've got the Getty Images cases. These are all ongoing cases in the United States. I mean, there hasn't been any decision yet, but essentially, the developer of the AI has taken codes from existing copyrightable works to use it as input into the AI machine, so that when any user of the AI machine wants something to be created, the AI would then use whatever has been inputted into the machine and come out with the new created work, right? So as you know, in AI created technology or AI created, the AI needs to be imputed, the AI needs to be trained as to what needs to be done. What are the parameters, what's the algorithms, what is it that you want the AI to do to come up with the end results. Now, in putting all that together, obviously you could, the developer or the programmer would source from what is already available in what we call the state of the art, and would also include copyrightable works. So the issue here that has arisen in terms of AI is whether or not by including some of these copyrightable works into the AI machine, has there been copyright infringement? All right. So it's quite interesting because, as you know, to prove copyright infringement, you need to show that there has been a reproduction of the copyrighted work, right? And there has to be substantial copying. So issues that arise from, and these are still ongoing, is has there been a reproduction of the copyrighted work, and has there been substantial copying, right? When what you've taken is bits and pieces and put everything together in the AI machine itself, right? So those are issues which are now being litigated in the United States. It's not been resolved. The Thomson Reuters case is quite interesting because Thomson Reuters, as you may know, is the owner of Westlaw and sued Ross for copyright infringement. Ross was looking to develop a competing legal research platform, but designed with AI. So the AI does the legal research for you. The platform will provide users with answers extracted from cases, like something like a chat GPT kind of function. So they claim that Ross, Thomson claimed that Ross had committed copyright infringement by relying on certain aspects of Westlaw's interface and code. So Thomson Reuters, of course, sought summary judgment against Ross, but the court denied summary judgment and said these were issues that need to go for trial. So it is the issue itself. This clearly shows that the issue itself by itself is not something that has a clear-cut answer. All right, the application for summary judgment failed and it has to go to trial. So these are still very, very live issues. All right. In the UK, we had something similar called Getty Images. Again, the Getty claims that Stability had used some of its images. As you know, Getty Images is basically a photo bank, right? It has a bank. It has a whole huge collection of a lot of photographs that you can use when you want to do presentations, when you're looking to do your projects, but you need to pay a license to Getty, right? So Stability was creating a machine, a software that will be able to mix and match some of these images together. But because they were relying on Getty Images copyrighted works, Getty claims that it was copyright infringement. Sounds quite clear cut, right? Unfortunately, the UK courts again denied summary judgment, and that the case will be proceeding to trial, right? So, as you can see, these are not clear-cut answers. The courts will need to look at the facts, analyze the law, and come to a determination whether or not there really has been copyright infringement. In Australia, there's been no decided cases on this issue. There is Section 40 and 41 of the Australian Copyright Act 1968, which talks about adaptation of literary works, copyrighted works, for purpose of research and study, and the other fair use defenses. It is questionable whether or not those fair use defenses will be available to a developer of an AI machine, because definitely it is not for research purpose, and it is for a commercial use, right? What's the position in Singapore? Similarly, is the Singapore in Singapore, the provisions of the Singapore copyright is very similar to that of Australia, and a bit of the UK provisions are also similar. Again, the issue has not really been decided. We do have similar fair use provisions as in Australia. And in fact, our fair use provisions are more closely aligned to that in the United States. But it's interesting to note that in the US, the courts have not accepted the fair use defense to any of these copyright infringement cases where where there's been taking of copyrighted works in training or developing AI machines, right? So the fair use defense in Singapore may not be useful to developers of AI, at least in Singapore. We do have the Section 244 of the Singapore Copyright Act, which allows some kind of computational data analysis. It's an exception, all right? So if the data is being used, or if it is part of a computational data analysis, then it would not constitute copyright infringement. The question is, it's really unclear if AI learning models really satisfy this requirement that it is for only computational data analysis. Again, this is something that will be left to the courts for interpretation. Right. So the next issue, of course, is similar to that in the UK proceedings, in the UK patent proceeding teller, which is basically can an AI generated work be protected by copyright law? All right. As you know, under copyright law, there are basically two issues to determine copyright ownership. One is that the work has to be original. All right. So, and the test of originality in most copyright jurisdictions are quite straightforward. It's a low threshold. So that's quite easy to ascertain. And then secondly is that there must be an author to the copyrighted work. So the question has come, that has been risen again in several of these jurisdictions. If I create, or if the AI machine creates a copyrighted work, will that work be protected by copyright laws, and who is the copyright owner? Mr. Taylor, again, tried to test the courts on this issue. All right. So you have in the US, Taylor attempted to register a work which he can call a recent entrance to paradise, which was autonomously generated by AI. So the whole piece of work, literary work, was written by an AI. The Copyright Office found that the work had no valid copyright, and Taylor was not happy, and they went up to the court. The district court dealt quite summarily with the matter. It upheld the Copyright Office decision, citing that authorship is synonymous with human creation, and therefore, you need a human person to be an author, and that it cannot be an AI, right? There's also another case, which is the Suyas case in the United States. A photographer, Ankit Sani, photographed a sunset and then used an AI painting application to apply Vincent van Gogh Starry Night as a style to the photograph. He's then attempted to register the work on the basis that as a copyrighted work, which was rejected by the Copyright Office on the basis that the work was not a product of human authorship, as an expressive element of the pictorial authorship was not provided by Sani. So what he did was he took a picture, he then got the AI to add on, all right, features. It's like, you take a picture on your mobile phone and then, you use the app to enhance the picture. And then you then say, oh, okay, I want to claim copyright in the picture. The Copyright Office said no. That final product was not created by a human author. Yeah, so there's been a couple more cases in the US which deals with this issue, where the copyright registration was rejected because there was no copyright owner. Right. Next, in Australia, the position is the same. Telstra and the phone company, they were in dispute as to who owned the photographs which were taken, and the court ruled that the author must be an actual person. All right. So in Australia, it wasn't had to do with an AI, but it was a dispute as to who owned the photographs. And in coming to a decision, the court ruled that under the Australian copyright law, an author has to be a real person, right? And we also have a similar case in Singapore, which is the Asia Pacific Publishing, which was a court of appeal decision in Singapore. This was not so much an AI-generated case, copyrighted work. It was a case where the author of the compilation was listed as a company and not a person. And so it then sued a competitor for copying the compilation. And one of the issues that arose in this case was, did the plaintiff, the company, own the copyright? When it came to determining the author of the compilation, the company listed it as itself and not an individual person. The Court of Appeal said then, that means that cannot be the case. An author has to be an individual person. And since that individual person was not identified, there was no copyright ownership in the compilation, and the company could not, of course, failed in its claim for copyright infringement. So I think in terms of authorship is concerned, and it's, I think, similar in line to that of in the patent cases, it has to be a person, a real person, in order to claim authorship. And the position in the UK, the US, Australia, Singapore seems to be consistent on this point. So what do you do then with AI created works? Who owns the copyright, or can there be copyright in AI created work? Actually, the answer is not too difficult. There have been cases There have been cases both in the UK and in Australia regarding compilation of data and data extraction. Obviously, if you compile data and you come up with some kind of a report, compilation of numbers, dates, whatever, you come up with a report, the work itself is a created work. It is a created literary work which is entitled to copyright protection. There is some originality. But how the cases have decided is that the owner, the author of those computer created works is actually the person who wrote. Robin. Sorry about that. Yeah. So the author of the works, the author of the computer created work is actually the person who developed the software. All right, who wrote the code for the software. So the courts have actually attributed authorship of computer generated works to the person who wrote the software that did the compilation. So a similar analogy can actually be drawn for AI created works. In other words, whoever created the AI, in this case, let's go back to the famous Mr. Teller. If Mr. Teller was the one who created Darius and he wrote the software code for Darius, so that Darius could perform certain things that would come out as an output side, then Mr. Teller will be deemed to be the author. So there is a solution. It is not a case where AI created works will not be entitled to copyright protection. It depends on who you claim to be the author. All right. Obviously, there could be other issues arising from whether or not there's enough creativity, whether there's enough originality, but those are again issues to be determined by the court. Right. Okay. Can we go to the next slide? Okay, these are just provisions from the UK. Basically, if you look at 9 UK Act, Article 9, 1 and 2 and 3, it's on the left-hand side, right-hand side, yes. Yeah, it says author means the person who creates it, right? So you're looking at a person, right? And look at 9.3, in the case of a literary, dramatic, musical, or artistic work which is computer generated, AI generated, the author shall be taken to the person by whom arrangements necessary for the creation of work are undertaken. So this is exactly what I was referring to. This is, legislated already, at least in the UK, that the developer of the AI, of the machine, which creates the copyrighted work, will be deemed to be the author of the copyrighted work. Right. Okay, next slide. Okay, these are just the fair dealing provisions, which I mentioned may not necessarily apply for imputed copyrighted work. I'm not sure you have something similar in India, but I very much doubt if you looked at, for example, 42, you need to look at all the conditions before fair dealing applies, and it's not likely that AI generated works will be considered fair use. Okay, on the next slide. Right, this is section 244. Again, this is what I'm talking about, data analysis. The copy is made for the purpose of computational data analysis. Again, the question is what constitutes computer data analysis. This is again left to the courts to decide. Okay, so basically, as you can see, the issue of AI and copyright law is still very much alive. There are a lot of questions that are yet to be answered. I mean, the courts have answered them, or legislation has answered them to a certain extent. For example, you still need a human touch to be a applicant or an inventor in a patent, or an author of a copyrighted work. In the UK, you can see that they have made provisions as to how you determine authorship of computer-generated works. But the door is still open to further discussions, on this issue. Okay, so I think that sort of ends where I wanted to talk about on AI and IP. I thought I'd leave the last couple of minutes open to questions. If anyone would have any questions, be happy to answer them.
If anyone has any doubts, I request to unmute themselves and ask your doubts. So I think Aditya has a question. He asked that in which jurisdiction is the fair use of defense not accepted?
I'm sorry, can you repeat the question again?
In which jurisdictions is the fair use defense not accepted?
Oh, in the US, most of the cases of fair use have been in the US. The US have not really accepted the fair use defense. And actually, the fair use defense in the US is very, very liberal. Even parody, you can even use it as a parody. We don't have that under Anglo-Singapore copyright laws, but the US does cover use for parodies and satires as a fair use defense. Even in the US, which as you know, is very liberal when it comes to fair use. Have not accepted it as part of when it's part of AI generated work or input. But that's the decided cases so far. As I said, there are a few cases that are still ongoing. Maybe the jurisprudence would change when those cases are heard, or if one of those cases go up all the way to SCOTUS, Supreme Court, then maybe we'll have some pronouncement on whether or not it's fair use.
So there is another question. Intellectual property of an employee reusable after left over the company is not an offense. He is asking whether it is an offense or not.
An offense? Sorry.
He is asking whether an IP of an employee is reusable after he left the company, whether it is offense or not.
Oh, okay. It depends. Okay, if you're talking of an employee, now the general rule, and this applies to both patents and copyright. The general rule that if you're an employee, whatever you create as part of your employment terms or your scope of responsibility, you help create an invention, you create some copyrighted works in the course of your employment, then the employer, the company, owns the copyright. So after you have left the company, you don't own the copyright. The company owns the copyright, so they are entitled to use the copyrighted works or the invention, because it belongs to them. Yeah. However, if it's something that you did outside your job scope, you did it at home, after office hours, when you and in the evenings or weekends, and it's nothing to do with your job, then that copyright belongs to you. And obviously, if the company were to use it, then they will be infringing your copyright.
Can I ask a question?
Yes, sure.
Yeah. Hi, sir. Good evening. Hope you are doing well. Thank you very much for this session. I have a couple of questions with respect to AI tools. One, say for example, using AI tool, if a person modifies or creates an advertisement using a celebrity, say for example, uh, uh, any actor. So I love some, say for example, I love Bruce Lee. Say for example, I used a AI tool and I create an advertisement using Bruce Lee uh, virtually. So say for example, Bruce Lee is advertising Coca-Cola, and company started publishing that advertisement. In this case, will Bruce Lee be entitled for remuneration, though he did not have not acted in that particular advertisement in any way he is related to that, or the company should in prior take any approval from this particular person, Bruce Lee, or how do we see this particular scenario? Will the company be liable to pay some remuneration, or will Bruce Lee be entitled for some remuneration in this regard? How do we see that, sir?
Okay, this may not be really copyright, but assuming that you use the film advertisement that Bruce Lee had acted in before, in the original advertisement, it depends on who owns the copyright. If of course Bruce Lee owns the copyright, and you then copy part of it, or the AI uses part of it, then obviously Bruce Lee would be entitled to sue you for copyright infringement, or if the company which is advertising, was say Coca-Cola, owns the copyright, then they will be entitled to sue you for copyright infringement, and not Bruce Lee. But Bruce Lee would also have another cause of action, not under copyright law, but it's an IP cause of action. It's what we call, it could be passing off, what we call passing off, or under privacy laws. I mean, the fact that you are now using him to create in another advertising film, there's an association that Bruce Lee is endorsing this product when he is not, because you have not sought his permission. So there could be a cause of action for passing off, and he could still claim damages against you.
Got it, sir. Thank you. And secondly, you were referring to, in most of the cases, in most of the case laws which you have now taught us, in most of the cases, they are mentioning one point. The law is mentioning about a person. Say, for example, if we have to sue under this copyright, the law itself is saying it should be a person. Since AI is not a person, they are not eligible to claim any loss because of this. Is my understanding correct?
No, the AI, they are, well, that's also one way of looking at it. So what you're saying, well, if I understand you correctly, what you're saying is that because a patent has to be filed in the name of a person, or copyright has to be there must be an author or a person, and therefore the invention or the final work product is not entitled to any form of IP protection. And that being the case, the AI obviously cannot claim any form of damages. Is that your question?
Yes, yes.
Yes. Yeah. So that would be right. So in other words, not only the AI, but everybody else will be entitled to copy that piece of work or whatever, and there'll be no damages to be paid, or no royalties to be paid.
Then in this case, people will start using the others' work widely.
Well,
Nobody will get
actually,
any.
the way around it is what Mr. Teller should have done. He should have just named himself as the inventor, as the applicant, and the inventor, rather than Darius. But I think he was just trying to prove a point, a legal point, that an AI can create an invention. Although I don't think he got very far in any of the jurisdictions.
Got it, sir. But if at all, if we can prove that way, then the creators in general will be saved and will be beneficial for them. Am I correct?
Yes. Yes.
Thank you so much, sir. Thank you.
So there is a last question. He asked that how partnership turned into sole proprietors using same codes, clashing in the market, which earlier common copyrights later separated, which voidable the copyright. Now, if both appears to have same code, copyrights any section, there will be an issue of copyrights. What can be the solution?
Actually, the partnership owns the copyright. Then we're talking of joint ownership, right?
Yeah.
Joint ownership. And so once you have joint ownership, things are becoming a bit more complicated. Each partner is entitled to, each person is entitled to use the copyrighted work. But he cannot divest himself of, or he in other words, it's like joint ownership of a house. If you want to sell the house, both joint owners have to sell the house. So here, while you can use it, you can't actually deal with it. I mean, you can't license it out, you can't sell it without the other partner's permission. So in other words, if the two partners own the copyright, say two persons own the copyright, and one of them says to a third party, hey, I'm a part owner of this copyrighted work. I allow you to use it because don't worry, I own 50%. That's not good enough. You still need to get the other 50% other person consent also, so that you have the full 100 or all the authors consent, all the owners consent, right? If there's more than one owner. Yeah. So there are complications with joint ownership of copyrighted works.
Sir, I have a doubt. AI often relying on vast data sets and algorithms. How do copyright and patent laws adapt to address the complexities of ownership and authorship in AI-generated works? And what can be the implications in coming future? I hope you understand my question, sir.
The implications, well, I think as you all are learning to be all law students and becoming lawyers, I think the implications will be there'll be a lot of work for lawyers. There will be, you all will be litigating some of these issues in court, trying to determine, who owns the end product. There's also discussions going on as to whether or not AI will replace lawyers. So yeah, I think I would say the implication. I think the implications is vast. AI is both good and bad thing. It's a good thing and a bad thing. It really depends on how it is used and how the laws are, I guess, made to accommodate AI and AI products.
So I think that's it. Thank you, sir, for very much elaborative, thought-provoking seminar of yours. And I would like to have a vote of thanks. On behalf of the Sri Venkateswara Law Students Association, I would like to extend a heartfelt gratitude to each and every one of you for your invaluable contributions to making today's webinar and a resounding success. I think for everything, it is the time that tells the answer, whether AI is acceptable as an inventor or author. And first and foremost, I would like to express our sincere appreciation to Mr. Alban Kang, Senior Consultant at Bird & Bird, Singapore, for sharing his profound insights and expertise on the topic of intellectual property in the age of artificial intelligence. Your presentation was enlightening, sir, and thought-provoking, and it has undoubtedly left a lasting impact on all the attendees. I would also like to extend our gratitude to the President of SVLSA, K. Pavan Kalyan, for his unwavering support and guidance in organizing this webinar. Furthermore, I would like to thank the IGNA legal team for providing us with the Zoom platform and technical support necessary for hosting this webinar. Your assistance has been invaluable in facilitating seamless communication and interaction among the participants. Last but certainly not least, I would like to express our deepest
Thank you.
I think, as I said, it's the time that has the answer. Whether AI can be taken as an inventor of the inventions. Thank you, each and every one of you.
Thank you.
Thank you, sir.